The Fifth Circuit Court of Appeals just issued its ruling in NADA and TADA's challenge to the CARS Rule, and never have I been so happy to be so wrong. As you recall, the CARS Rule was published last January 4th. NADA and TADA immediately challenged it before the Fifth Circuit Court of Appeals. For brevity, I will refer to both petitioners collectively as NADA. The first big surprise came on January 18th, the very day when the FTC was required to respond to NADA's request for a temporary stay of the rule. Instead of filing their opposition brief, the FTC voluntarily stayed enforcement of the rule. The case was briefed on an expedited basis, and oral arguments were heard on October 9th in New Orleans. After all of this took place, there were three possible outcomes to the case. One, the FTC could prevail, and the CARS Rule would go into effect at a date to be determined. Two, NADA could win outright, and the CARS Rule would be dead, at least for a while. Or three, the court could remand the rule back to the FTC with instructions to fully consider the issues NADA had raised in its lawsuit and, if appropriate, modify the rule to address those issues. In other words, split the baby and make the parties work things out. Listening to those arguments and reading the briefs led me to the conclusion that the CARS Rule would be remanded to the FTC. It seemed like the path of least resistance, and one of the judges on the three-judge panel specifically asked if that was a possible outcome. This was an unnecessary question, as NADA had offered that as an alternative outcome in its brief. So it was a question that didn't even need to be asked. I took that as a clue that the court would take that route. I was wrong. On Monday, January 27th, the day after the annual NADA convention ended in New Orleans, the Fifth Circuit issued its ruling. In a 2-1 decision, Judge Higginson dissenting, the court ruled in favor of NADA and vacated the CARS Rule, killed it dead. For those of you who really geek out on the lawyer stuff, the court held that the CARS Rule was an 18A1B rulemaking, which required the FTC to issue an advance notice of proposed rulemaking, not an 18A1C rulemaking, which does not. Because the FTC did not issue an advance notice of proposed rulemaking, their procedure violated their legally required procedure, and the rule had to be set aside. What does this mean for car dealers? Well, the most important point to understand is that the death of the CARS Rule does not make deceptive trade practices legal, even if the FTC made it sound like the CARS Rule was why those practices were illegal in the first place. It was not. The CARS Rule was issued, when it was issued, in response to a unanimous Supreme Court ruling in 2021 that declared the FTC could not assess monetary fines in the first instance except for violations of specific trade regulation rules. The FTC CARS Rule was that trade regulation rule, and if all it did was codify certain flavors of common law fraud, it would probably not have been challenged. But the FTC overreached and added aggressive features like express informed consent and disclosure and advertising requirements surrounding offering price that truly made the rule objectionable. So NADA objected. Where do we go from here? First, if you do any of the 16 bad acts identified in the CARS Rule, stop doing them. They are still illegal. Consider implementing a written policy that specifically prohibits such actions at your dealership and train all relevant employees on that policy and the laws it supports. In other words, Take away the ammunition the FTC wants to use against you. Is the CARS rule good and truly dead for all time? Maybe not. The FTC could petition for rehearing before the same 3 judges. Not likely. Or for an en banc reconsideration before all of the full-time judges of the Fifth Circuit. This too is unlikely, as such petitions are rarely granted, and in any event, the current Federal Trade Commission lacks a 5th commissioner. President Trump's nominee for that tiebreaker slot is Mark Meador, who has not yet been confirmed by the Senate. With 2 Republican and 2 Democrat commissioners, I don't see any action for rehearing as likely before the time limit for such action runs. Finally, there's always the possibility of an FTC appeal to the Supreme Court, but that is also a very, very long shot. Could the CARS rule come back? Maybe. A fully manned Federal Trade Commission could go back to the drawing board, issue an advance notice of proposed rulemaking, and issue the CARS rule again. That could take a year or 2, but it could happen. But if it does, I expect it to be far more modest in scope and far less likely to be challenged in court. The bottom line is very, very good news for the retail automobile industry and for the car buying public. Our thanks and congratulations to NADA and TADA for carrying our water so effectively. Great job, guys. For Drop the Bow Tie, I'm Jim Ganther. Thanks for watching.